All right, we are on part 3 of ways to hold title to real estate in California. All right, so we've already covered tenants in common and joint tenants. We are now moving on to the wonderful world of what is available to married people in California. And it's married people and registered domestic partners. So these next 2 videos are going to be specific to people who are married or in registered domestic partnerships in California. All right. Surprise, surprise. This one is community property. Okay, and what the hell is community property? So California is a community property state. So this is a little 2-in-1 video. Community property means the assets that you acquire during your marriage or during your registered domestic partnership are community, which means they belong to both of you equally. The assets that you acquire prior to your marriage or prior to your registered domestic partnership, unless you do something different, will remain your separate assets. They are not part of your community estate. All right, so that sets up the basis of what is community property. That's that. It's the stuff that you acquire inside of your marriage or inside of your registered domestic partnership together. Okay? There are some exceptions to what is acquired during your marriage or during your domestic partnership. That is not a community asset, and that is not for this video. All right, so when you have the option to select community property, what does that mean? Community property means that the spouses have the ability upon their death to will away 1/2 of their portion of the property. Yeah. So what that means is that there's no right of survivorship for the spouse, meaning when spouse number 1 dies, they don't automatically own the whole property unless spouse number 1 has done some estate planning that says where it goes. And the same thing, if you die without an estate plan, the state will say, where is this going to go? There are a lot of things that can happen. It's not cookie cutter. It's not just, oh, well, I'm the surviving spouse, so I'm automatically going to get it. Nope. So that's the biggest difference between all of the 4 ways that you can hold title. But specifically for spouses, this is an opportunity where you can actually will away your portion of community assets. Okay. The next thing, and this is not something that I particularly like, just because the way that we practice real estate law and the way that our title insurance companies and our escrow companies work in California is that creditor rights. So if you owe somebody money, let's say they have a judgment against you. For community property and community property with the right of survivorship, they have very similar rules as far as what can a creditor look to for your real estate to satisfy whatever judgment that you owe them. On its face, if there is a judgment against just one of the spouses or domestic partners, that the creditor can't look to that property to satisfy the judgment. In practical speak, though, if you go to sell or you go to refinance this property and there's a judgment against just one of the partners or one of the spouses, the title company they don't give a shit. They want you to pay that debt, period. With community property, the only time that you can actually will away your 1/2 interest is at your death. You can't do that during your lifetime. So let's say you have a judgment against you and you're the only one on this judgment. It's not against both of you. You're the only one on the judgment. You can't unilaterally decide to sell your 1/2 interest in this property to satisfy that judgment. So it is what it is. It's kind of goofy, but creditor rights protections regarding community property, it's a thing. Just the way that we handle it in like real life doesn't really matter. Like you have to pay that judgment in order to make it go away. And when I say pay or you figure out another way to make it go away. But that is what community property is. Community property is only available to married people and registered domestic partners in the state of California. It allows one spouse upon their death to will away their 1/2 interest in the property, either through their will or their trust. It also does not presume that the surviving spouse or registered domestic partner gets that other half. Okay, and then we have the creditor's rights protections, which if you're using the property to satisfy it, you got to sell the whole thing. Okay, stand by for our very last installment of how to hold title in California.